Welcome to FAQs on TPR number 1. I'm Jeannie Gordon, the Legal Issues Training Coordinator for the Children's Division. We're here today because it's time for TPR talk. You either have one of two situations. You've either been working reasonable efforts for a year and the kids just aren't in position to go home, and you're looking at whether or not to implement a concurrent plan of TPR and adoption, and you want to know whether or not you have a TPR ground and what that ground would be. Or you're at the very beginning of the case and you have what you think is one of those statutory exceptions that would allow you to go straight to TPR and adoption and opt out of reasonable efforts, and you want to make sure that you know which one of those it is. So what we're going to do today is we're going to discuss the basics on the elements for the TPR grounds: abandoned child, abandoned infant, failure to rectify, and parental unfitness. And then we're going to use the FAQs, the frequently asked questions, to apply real life situations to these elements and show you how the different grounds work. Just so you know, these FAQs are based on questions that I've been asked over the years from Deputy Juvenile Officers and Children's Division and other FST members regarding termination of parental rights. I think that probably the grounds that get used the most are abandoned child and failure to rectify. So of course those two are both going to be in this taping today. There's one last thing that I'd like for you to remember as we go through this. You have to remember that TPR is not just about best interests when you're looking at a Chapter 211 termination of parental rights case. Built into the statutes is a balancing act between parental rights and the best interest of the child. So you're going to see that play out as we talk about these different grounds for termination of parental rights. So let's take a look at the goals of the training. The goals of the training are to make sure you have a basic understanding of the elements of TPR for abandoned child, abandoned infant, failure to rectify, and parental unfitness. Let's begin with abandoned child. There are 4 elements required for abandoned child. The child has to be over 1 year. You have to have a period of the most recent 6 months when there's been no parental contact and no support, although the parent was able to do so. Again, this looks like probably one of the simplest TPR grounds, but it's also one that I probably get the most frequently asked questions on. So let's start with the questions. Child over 1 year, that makes sense. You're looking at today, is the child a year old? The child has to be at least a year old at the time you file the TPR petition. So you're looking at the age of the child. How do you count the 6-month time period? This is a very frequently asked question. Well, you're looking at today and backwards for 6 months. You're looking at the 6-month period from today backwards. You're looking at whether or not there's been parental contact and support. Well, why that? Well, it says the most recent 6 months. And what the court's going to look at, the appellate courts, what they look at is the most recent 6 months from the filing of the TPR petition. So you're going to look at this 6-month period from today backward to see whether or not you have 6 months with no contact or no visitation, no support. Sometimes the question comes up, well, you know, a year ago we had a 6-month period of time where the parent was having no contact or support, and then the parent showed back up and started visitation and have been doing what they're supposed to, and then guess what? We had another period of time where we've got 2 or 3 months. Can we base it off that 6-month period of time that happened a year ago? And the answer is no. You have to look at the most recent 6 months is what you're looking at, not something that happened a long time ago. Let's take a look at element number 3. Again, we're looking at there's been no parental contact with the child and no support. So the most frequently asked question on this one is, well, how do I count that? Because the parent has had contact with me at least 2 or 3 times in the last 6 months period of time. So do those contacts count? And my answer is no. If you look specifically at number 3, there has to be no parental contact with the child. So obviously, the important thing about them contacting you, you're either offering visitation and they're not doing it, or they're not asking for visitation, and I always recommend that you go ahead and offer visitation to them. But there's no visitation or contact with the child, but obviously if they can pick up the phone and talk to you and know how to contact you, then they should be able to pick up the phone and have phone contact with the child or be able to arrange visitation with the child, which kind of goes to that element, number 4, that we haven't gotten to yet. All right, on number 3, what counts as contact? What counts as parental contact? Well, it's visits with the child, calls to the child, emails, letters, cards, books on tape, maybe even Skype, if there's some way the parent and child can have contact. Now, what counts, whether it's supervised or unsupervised or therapeutically supervised, the idea is they're having contact in some form or fashion. Visitation is always the preferred method, especially for engaging that parent so that you can reunify with them. But these other methods work too. What counts as support? Remember, it's no parental contact with the child and no support. Well, we're looking at money. We're also looking at in-kind contributions. So you want to make sure that you have documented the times the parent brings clothing to the visits or brings food and cookies to the visits, that they remember the child with birthday presents, Christmas presents, things like that. You want to be sure those are all documented, either by the worker because the worker is involved with that part of it, or if they're in a relative placement or other resource home, you want to make sure that foster parent or family member is documenting exactly what it is and documenting the dates of it so you've got that information. Child support is always a question. Child support, they may pay regularly, they may not, but a lot of times we have child support that's ordered on our parents, either through child support enforcement or sometimes the juvenile judge will order support to be paid. So either way, you're looking at whether or not there's ordered support and whether or not they're paying. Garnishment comes up. Do you count it if it's garnishment? Child support. Is it child support if it's garnished? Well, you think about it. There are a lot of parents that the parent that's paying support doesn't want to have to deal with that other parent or ex-spouse of theirs, or there's been lots of friction. So garnishment is actually one of the easier ways to do it, where that parent that's paying the support doesn't have to have contact with that other parent. So as long as if it's being garnished, that means it's being paid on a regular basis. And I think if they pay support on a regular basis, then you don't have that element number 3 because they're paying on a regular basis. How do you know what they owe if there's an order of support? The division has access to child support arrearage calculation, so you can always get that information that shows. So if there's 1 or 2 payments of support in a 6-month period of time, you're probably all right. If they're paying on a regular basis, then you probably don't have that particular element. Another question that comes up when we're talking about support is, how much does the parent have to pay? It really comes down to what they can afford to pay and what the courts are looking for, the appellate courts, when they write these decisions. They're looking for the parent making regular support payments in an attempt to maintain the parent-child relationship. So they're doing what they can. A question that comes up is, what doesn't count as support? I think an occasional payment of support doesn't count. I think a tax refund intercept does not count. That's a one-time thing usually. And part of the reason I talk about these not counting is there's actually part of the TPR statutes. There's a section that says the court can attach little or no weight to infrequent support or contact and visitation with the child. So if you have a one-time tax intercept or 1 or 2 payments of support, that's probably not enough to say that they're paying support, so you would still have that third element. So you just need to be able to say how many there have been. The biggest issue of contention is probably the 4th element, which is the parent has to be able to do so. Well, has to be able to do what? They have to be able to have visitation or other contact, and they have to be able to pay support. So we see a lot of questions in this particular area. And the biggest issue I want to talk to you about is court orders of no visitation or any other contact. When you have court orders of no visitation or any other contact, then the parent is not able to visit or have contact, and therefore you don't have an abandonment case. So that's something to keep in mind. What would other examples be about the parent not being able to have visitation or contact? Well, think about the parent who's in the coma. A parent's been in a car accident, has a traumatic brain injury, is in a nursing home in a coma, and will be so the rest of their life. That's an example where that parent is not able to pay support or have contact with the child, and therefore you can't do an abandonment TPR grant on them. What else do you look for in terms of being able to visit or pay support? And I think really what you're looking at is the parent who comes to your FST meeting or the parent who comes to court. They don't have to be employed. The idea is they have to be employable. So is the parent able-bodied? Are they able to get some sort of work? Unless you see some sort of disability that would keep them from getting any type of work at all, then I think they're able to pay support, and I think they're also able to have contact. Again, we talked about this a little earlier. If they can contact you, if they've got a phone and can contact you to ask about the child, then they would be able to have some type of contact or support, or some kind of contact with the child. So that's another way to look at that. How does this apply to this abandoned child apply to the incarcerated parents? And I think this is one of those mistakes that happen on a pretty regular basis. When the parent is incarcerated, that parent is kind of out of sight and out of mind. And if we're not working reasonable efforts with that parent and trying to engage them in the possibility of some type of relationship with the child, or if they're going to get out of prison within 6 months or a year or two, we need to be working reasonable efforts with them. And when we don't do so, sometimes we think we can make the abandoned child case, and I'm telling you, it's very difficult if you don't try to work with the incarcerated parent. So what does that mean in terms of abandoned child? Well, to begin with, incarceration in and of itself is not a TPR grant, and it says that in the TPR statutes. You have to prove the same elements of abandonment for an incarcerated parent that you would do for a parent in any other case. So the problems that usually arise are on that fourth element, which is whether or not the parent is able to have parental contact with the child and whether or not the parent can pay support. And I think one of the greatest things you can do is when you send that parent the incarcerated parent letter, because you're trying to engage them, explain to them the need for a relationship with the child, to pay support, to support their child, and to maintain that relation, which would be some time of parent-child contact. And I think that's very important. And then on the flip side of that incarcerated parent letter, it also talks about if you don't do these things, you may end up with your rights being terminated. And that is very fair to the parent. It's very fair to the child trying to work with them. So for the incarcerated parent, what can that parental contact with the child look like? Well, it could be letters and cards. Parents can write letters from prison. They can do drawings and send them to the child. They can do books on tape, and you especially see that in Vandalia, where the mom's prison. Sometimes they can have telephone contact, and what you might consider is if you're getting that incarcerated parent on the phone for your family support team meetings, include the child in the meeting, and either before or after as the meeting starts, let the child have some contact with their parent. What about visitation in prison in person? Well, first of all, there's a lot of factors that go into that, and you want to look at very child-specific conditions. Does the parent want the child to come to the prison? Is the parent allowed to have the child come to the prison? Based on a conviction, they may not be able to have contact with a minor child. Or based on the fact that they've had some volitional contact on their part that's placed them in administrative segregation, they may not be able to have contact with the child. Is the prison location safe? Do they have a child-friendly area for visitation? And do a child-specific analysis on the other things, such as the age of the child, the distance to the prison, who's going to get them there, all those informations, and let your judge decide on whether or not that visitation in person can take place. Sometimes visitation too can be visitation or other contact would be those letters and cards that need to go through the worker. Maybe they need to be reviewed before they go on to the child due to the concerns for the material that would be in them, or if there's been some serious harm to the child, you may even need for the letters or cards or other contact to go through a therapist to decide when it's appropriate to give them to the child. So that's the contact piece on that. What about when the parent's in prison? Can they pay support? Are they able to? Just because they're in prison doesn't mean they're not able to pay support. You will find, I think, that most of those in prison, unless they have some kind of very serious disability, are able to work. The going wage, the last time I did a TPR, was around $8 a month. So the parent gets $8 a month that goes into their bank account that they can spend for things they want to. What the case law says is a minimal amount of support is enough. So even the cost of a postage stamp to put on a letter to send to a parent would be considered enough to maintain the parent-child relationship as long as they're doing it on a regular basis. Oddly enough, you always wonder, can you do a TPR on a dad when he can't come to the hearing because he's in prison? Actually, the dad is entitled to come to the TPR hearing in most cases when they're in the Department of Corrections. There's a statute out there, 491-230, and it talks about what's needed in order for the parent to be able to come to the hearing. The attorney for the parent has to request it well in advance of the hearing to give DOC time to respond with any objections to transporting that person back to the jail so they can go to the TPR hearing, and then the judge rules on that. But in most cases, if they're in a Missouri prison under the Department of Corrections, then they can come to the TPR hearing. One of the biggest issues in these abandonment cases is you've got these parents that haven't done anything they're supposed to do. For a 6-month period, you file your TPR, and you're ready to go on an abandoned child on this particular one, and lo and behold, up pops a parent and wants some visitation. What do? And if they request visitation, my bottom line is, unless there's some type of huge safety risk to the child will be in a supervised environment, and the parent should be allowed to have the visitation. And why do I say that? There's a concept called repentance. That's a legal term for it, where the parent realizes they've been a bad parent and they come back and they want to correct it. And I'm not so sure that's a bad thing. If the parent comes back after you file that TPR petition and they have a visitation, supervised visitation, and they stick with it and continue to visit on a regular basis, then you're probably not going to have enough for a TPR. But that's not a bad thing if the child can go home. But I think in most cases when our kids haven't seen the parents for 6 months or more, those visitations don't necessarily go real well. And they're supervised. The kids have someone in there that they know and care about, that they feel safe with. If they're smaller kids, they may not know the parent at all, and that parent thinks they're going to have this rosy reunion with this child, and the child screams and hollers through the visits. They may come back for another shot, or the parent may never come back at all. In the older kids who haven't seen their parents for 6 months or more, they may be openly hostile, verbally hostile to the parent for the lack of not having that contact. And so that doesn't play well for the parent either. But you've attempted to make that reasonable effort to give that parent a chance to renew that relationship, and whether or not they're willing to do it on a regular basis. So you document the results on however it goes. Remember, this is one of those that shows you the balancing the best interest of the child with those parental rights. Sometimes, when I was talking about, I think you need to plan. I think when you go to TPR and you file an abandonment TPR petition, you need to talk to the team and say, this is our plan if the parent calls and says, I want visits. And you need to have that plan in place in case that parent calls. Because it's much harder if the parent calls and you say, oh, I can't set up visitation with you, I have to talk to the team. Or give them some other reason. I think you need to have this planned in advance on how you're going to handle it to make sure that you can move smoothly forward with that visitation or not. And sometimes our kids have really serious problems based on serious abuse by that type of parent. And those visitations, if they took place at all, would have to be therapeutic visits, or maybe you have a court order with very detailed findings on the abuse or whatever this child has suffered at the hand of that parent and why it's not appropriate for them to have that visit. But again, unless they should get the visitation, unless there are some safety issues that cannot be controlled by supervised visitation. Okay, I have, I think, 3 last questions and we'll finish with abandoned child. So, the worker has had no contact with the parent for 6 months. Is that enough? We talked about this one. The element requires visitation or contact with the child, not the worker. Look at the contacts and visits with the child. Look at whether the parent has paid support or not. The other one you want to look at is you've got a parent that's not had any contact for years with the child, and you find out that that parent has been paying support on a regular basis based on a child support order from many years ago. So this other parent, usually a dad, has another family. There's nothing wrong with him. He's got kids. This was just something from his past. It didn't work out. He's not having any contact, but because he's the father, he's been paying support for years. You do not have an abandoned child TPR, because it has to be no contact and no support. And in this particular case, that parent isn't really interested in any kind of contact or relationship with the child, but they have stepped up and paid their child support obligation all these years. You do not have an abandoned child. Sometimes on those cases, you will have that particular parent is more willing to sign a consent to TPR. But just keep that in mind. You have to have both, no parental contact and no support. Here's the next question. Dad's accused of sexually abusing one of the kids. The kids come into care. As part of Dad's bail conditions, because he's been criminally charged, but he's been let out on bail, he cannot have contact with any kids, and he cannot have contact with his own children. And it turns out all along he's not paid support. It's now been 6 months, so he's had no contact with these kids for 6 months, and he's paid no support. Can we do a TPR for abandoned child? And my answer was no. The parent has to be able to visit or have contact. And in this particular case, you're missing the one element. You're missing the element of him being able to have contact or visitation, because there's a bail condition that says he cannot have any contact with his kids. So no abandonment TPR in that particular case. So it's not just juvenile court orders that may cause you problems with this that you need to look closely at. It's also bail conditions or probation conditions or parole conditions, depending upon what you're looking at. Another question, the permanency hearing isn't held until the first year. I didn't know that you could go to TPR on abandonment, abandoned child or abandoned infant, if it's less than a year. And this question has actually come up a number of times. I will just tell you, at any point in the case, you can go back to court and change the permanency plan. Your team has to make a decision. You do it like you would do any other permanency hearing. If you guys decide that reasonable efforts are no longer required and it's in the best interest of the child to move on to TPR and adoption and implement that concurrent plan, then you go back to court. That's the way the model is constructed. You go back to court and the judge can change the permanency plan. There's not a 1-year requirement for abandoned child. If you noticed, it's only a 6-month requirement. And the reason most of the time we see the 1 year involved before the team changes the plan to TPR and adopt is because that's going to be what I tell you is the good social work TPR ground. That's your failure to rectify ground will match up with that pretty well. The last piece on abandoned child is we're going to move to the slide on what if the child's identity is unknown? Well, if you have an abandoned child, that means they have to be over the year of 1. So you're going to have a pediatrician. Since the child's identity is not unknown, you don't have a birth certificate, so you don't know date of birth and you don't know the age. So a pediatrician is going to have to examine the child and give you an opinion that this child is over the age of 1 year. And then you'll have to have 6 months where there's been no parental contact or support with the child. The identity of the child is unknown and the child is unclaimed. I mean, that one's pretty clear. if you don't know who the child is and the parents haven't claimed him, it may be very difficult to find out who they are. So you just have to meet those 4 elements. So at that point, we're going to end on abandoned child. So let's take a look at the ground abandoned infant. So abandonment really is what I'm telling you comes in 2 flavors. You've got the child that's over a year, that's abandoned child, and then you've got the baby that's under a year of age, and that's going to be your abandoned infant. So there's 3 elements. The child is less than a year old. The second one, no parental contact with the child and no support. Number 3, although the parent is able to do so. Okay, it looks a lot like abandoned child, but there's something missing. What's missing from the abandoned child ground? Well, abandoned child requires 6 months, but the abandoned infant does not have a time requirement. And why is that? This is one of those exceptions to providing reasonable efforts to reunification at the beginning of the case. The idea is if you have a very small baby that's been abandoned, then there's no time requirement. The idea being you can move the child on to TPR and adoption much faster. So, you know, how long does it take to do an abandoned infant case, or what period of time are we looking for? I will tell you, and I'm not a big fan of rule of thumb, but as a general rule, it'll be about 60 days is what you'll have before you can get there. That used to be in the statute. It's no longer in the TPR and adoption statute, that 60-day requirement. It still remains part of the 453 requirements. If you're doing TPR and adoption in one fell swoop by the attorney for the adoptive parents, they have that 60-day requirement to meet if the child is under a year of age. If you're doing a 211 abandoned infant case, you do not have to have that 60-day requirement. But I think it takes you a while to get there because you're looking for a juvenile court adjudication determining the child to be abandoned, or you're looking for the filing of a 2-count petition, 1 for a determination that the child's abandoned and 2 for termination of parental rights on that particular issue. So how old are we talking about the child? I think you want to do it at least before the child is 9 months old. And why do I say that? You don't, when the child gets to be closer to a year, then you filed the petition when they're under a year, but you tried the case when they were over a year. We don't want to do anything that creates issues for appeal at the Court of Appeals, and there's no case law on that particular point at the Court of Appeals. So I would look very closely at, you know, at the 4-month mark, at the 6-month mark, at whatever period of time you've got pretty much a 60-day period of time you want to move forward on that abandoned infant. But again, like I said, there's no 60 days set in stone. It just sometimes takes that long to get where you're going on that particular one. All right, so we're going to look at the second slide on abandoned infant. So please know, we talked about when you know who the child is. Now let's talk about how you do an abandoned infant case when you don't know the child's identity. This is going to be your safe haven for newborn child. Again, the child is less than a year old. How do you know the child is less than a year old? Again, you're going to have to go to the pediatrician and have the pediatrician tell you based on the developmental facts based on this child how old the child is, and that will be your basis for the child being under 1 year. And again, you've got the identity of the child is unknown and the child is unclaimed by the parent. And you're going to make efforts to try to locate him but may not be able to, and that applies on that particular one. Let's move on to the failure to rectify TPR ground. And I think this is one you see the most because most of the time we're working with a family a year before and get to the permanency hearing before we're changing the plan to TPR and adoption. And so I call this the good social work TPR ground because it's really designed to match up with all the good social work you've done in your case. And I'm just telling you, if you haven't made good faith efforts to work with the family and provide them all the services they need so the child can go safely home, then you're probably not going to have this TPR ground or be able to use this one. This all works with the reasonable efforts piece. So we have to have 3 elements and then we have to have 1 factor that are required. So let's march through the 3 elements, march through the 4 factors, and then we'll apply it with questions, the frequently asked ones. So the 3 elements that are required is juvenile court jurisdiction over the child for 1 year. So that matches up with our permanency hearing. So you've had a year to provide reasonable efforts to that family. You've had multiple court hearings. You've done a lot of written service agreements during that first year. The second element requires the harmful conditions which led to custody to persist. That means whatever brought the child into care, whatever those harmful conditions are, they still exist right here now when you're making that decision on whether or not to go to TPR. Now there's an or, so you either have to have the harmful conditions that brought the child into custody, or during your year of working with the family, you've had other potentially harmful conditions come up such that you can't return the child home. So that would exist today while you're looking at this case and you're saying, I can't send this kid home, and here's why, because these other conditions that came up during the year we've been working with this family. So you have to have 1, you have to have 2, and you have to have 3. So the third one talks about these conditions cannot be quickly corrected for reunification, and there's an or the parent-child relationship deprives the child of permanency. And I would like to concentrate on the first half of that. If you will think about it, if you've poured all your reasonable efforts into this family to prevent removal, and then once the child's been removed, you work all your services to try to return the child home, and you do it for a year, and something harmful, some type of harmful condition still exists, do you really think it will make any difference to your case if you provide those same efforts to that family for the next few months? I think that's how you kind of look at that. Now, if there's some big area you missed, like maybe you missed that the parent had an underlying mental condition, and you're at the year mark and now realize, oh, she really needed a psych eval and we never tried to do that. Well, then you haven't provided all your reasonable efforts and you may not be able to make this one. But in most cases, in almost all cases that I see, you've targeted the services the parent needs from the beginning of the case, done multiple written service agreements, you're at the 1 year mark, and the child isn't going to be able to go home quickly. And even if you pour those same services into that parent for another 3 or 4 months, it isn't going to make a difference. And that's how you make that third one. The other part of it, that the parent-child relationship deprives the child of permanency. I think that's important too, but I think the courts focus more on the conditions cannot be quickly corrected for reunification. So those are your 3 elements. You have to have all 3. On the next page, we talk about the factors. So if you think about what brings kids into care, what is it about the parents that cause harm to happen or very high risk of harm to be there, that we're so worried about the imminent danger to the kids that they come into care? Well, generally there's underlying mental health issues. There's underlying drug and alcohol problems. Those are 2 of the big reasons why kids come into care. And if you look at that, that is number 1 and number 2 of the factors that are required. So the court has to look at all 4 of these factors, and in order to make a TPR case, you have to have at least one of them. And sometimes you'll have more than one, but you have to have at least one. So let's start with these underlying conditions I talked about, and the first one would be the mental condition. The parent has to have such a severe mental condition that they are unable to parent the child. That's the plain English. So it's just the fact that it's apparent they have a mental condition isn't going to be enough. You have to be able to connect the dots between the severity of their condition and their inability because of it to provide a safe care, custody, and control for that particular child. And we'll talk a little bit about what that can look like as we go through the FAQs. So the second factor is the untreatable parental chemical dependency, and I know social workers don't like the term untreatable, but it's a parental chemical dependency such that the parent, again, is unable to parent the child. And we'll talk about untreatable, but you're looking at they've made various attempts to inpatient or outpatient to correct the problem over time, or they've given up completely and are no longer willing to do any type of rehab or anything that will help them with their drug or alcohol problem. That's kind of the basics of it. But again, it has to be, that chemical dependency has to be so serious that they're unable to parent the child. It doesn't work if mom and dad have a cocaine habit, but when they decide to binge, which is on the weekends, they send the kids to grandma and grandpa's. And then, they go back to their jobs on Monday and the kids come back home. The kids are safe. There's no effect on the kids. So that's not going to work in that particular case. All right. The third factor is the social service plans and extent of parental compliance. And I think this is the main workhorse for the failure to rectify cases, because remember we talked about the failure to rectify case is the good social work TPR grant. And in order to get the judge to grant the TPR and you be able to move on to adoption, you have to take all that good social work and put it in the form of evidence so that the judge can meet the burden of proof that's required for these TPR grants and make that decision. And so the social service plans, what are those? Those are those written service agreements you do throughout the case. And in almost all cases, you work reasonable efforts with the family. So in almost all cases, you're doing written service agreements with those parents. You do multiple ones, and you're trying to address the issues that brought the kids into care. You're also looking at the extent of parental compliance. Are they complying or not? What are they complying? Which portions of the written service agreements are they complying with, and why or why not? And that's the one I think you see used the most. The last factor is the success or failure of efforts to aid the parent to change. So although it looks like the focus is on the work the FST did, the focus really is on we've provided all these reasonable efforts, and why or why not, why didn't the parent change? What were their reasons for not changing? So that's how you use that one. I still think number 3 is probably the one that gets used the most. So now let's go back to the slide before on failure to rectify, and we're going to do the frequently asked questions that come up on those first couple of elements. The biggest one is, how do you count the year? The kid comes into care, that jurisdiction attaches on that date, so it's juvenile court jurisdiction over the child for 1 year. So it's the date the child comes into care, or the adjudication, whichever is done first, where the child comes into care, and you count a year from that date. You have to have that period of time. Okay, so how does the fact that the child is on a trial home placement play into the counting? Well, it doesn't play into the counting on juvenile court jurisdiction. It plays into the counting on the ASFA requirement of 15 to 22 months, because the requirement is if the child's been in care 15 of the most recent 22 months, then you're supposed to move on to your concurrent plan of TPR and adoption, unless you've got compelling reasons not to, or one of the other exceptions. How do you count the 15 to 22? Well, it's the time the child's in a foster care placement or relative care placement. You can't count the time that the child is home on the trial home placement. So just remember that. Okay. Let's look at the second element. This would be an example of when you use the second set instead of the first set. So the first part of number 2 is the harmful conditions that brought the child into custody still persist. Well, sometimes I'm going to tell you the parents have fixed that, but there's something else that's come up during the case that's very harmful to the child. And so this is an illustration of that. The children came into care a year ago because of a really serious, unsafe, and unsanitary household. We're at the year mark. We're at the permanency hearing. Mom and dad have cleaned up the house, and it remains clean. But after the children had been in care for a few months, and this is post-adjudication, the kids started disclosing sexual abuse by the parents. Consequently, that was adjudicated on, and at the time of the permanency hearing, was at the 1 year mark, the parents were still in denial that they had sexually abused the kids, and that was a potentially harmful condition that existed at the time of the permanency hearing. So the parents were wanting to continue to work reunification because they cleaned up the house, and the courts said, no, it's okay to move on to TPR. You have that second element because that sexual abuse that happened was another potentially harmful condition that existed at the 1 year mark. Okay, so that's how that works. Sometimes you only have the harmful condition that brought the child into care still existing at that year mark. Sometimes you have the other condition that's come up since existing. Sometimes you have both. Okay. here's a question that comes up quite a bit. The parents have been having unsupervised visits for months now, but the team thinks we need to TPR so the foster parents can adopt the kids. Can we make a TPR? Well, let's talk about what the failure to rectify means. The name failure to rectify may be a little too short. It should be failure to rectify the harmful conditions. So if the kids are home with unsupervised visits, then what are the harmful conditions that exist between the parent and the child? I don't think they're there, and I don't think you can make a TPR. What is unsafe about the parents or their conduct with the child if they're having unsupervised visits? I don't think it's there. I don't think you have a failure to rectify harmful conditions. So that doesn't work. Okay. Let's see. We talked a lot about the conditions cannot be quickly corrected, that third element for reunification. And that really is just you do all those reasonable efforts up front in the case, and a couple of months are not going to make any difference. Now, once in a while for TPR, the parents have made some strides that are significant in nature shortly before the permanency hearing. And at that point, yes, you're going to ask to provide additional reasonable efforts and let the plan remain reunification. That makes absolute sense. Okay. Let's look at the factors again. Let's start with severe parental mental condition. Let's start with that. Clearly, this comes up quite a bit. And I think as a non-attorney out there, sometimes you see these parents and you see why the child's come into care, and you really think that they are really having a hard time just taking care of themselves. So it's just self-evident that they can't take care of the child. And you wonder why the case hasn't gone to TPR. And here's an example. Mom is very low functioning. She can't tell time or fraction to fix formula for the new baby. She will never be able to care for the child. She's having a very difficult time caring for herself. Why hasn't it gone to TPR? Well, again, the failure to rectify case is going to last a year. You have to have a severe parental mental condition. So don't forget, mom still has constitutional rights that have to be protected. And you can't do termination of parental rights unless she gets her full due process, which means you have to have a TPR ground that exists under state law, and you have to have enough evidence to prove that TPR ground, including this mental condition part, before you can TPR. So what does it really take for a mental condition? Well, it takes three things. You have to have a documented mental condition, which means you have to have an evaluation done such that there's a DSM-4 type diagnosis. And sometimes you can't get these parents to do the psych eval. If you can't get them to do the psych eval, then you're not going to be able to make the mental condition. So you need the documented mental condition. It has to be permanent or not likely to be reversed. So a lot of times on the permanent ones, you're seeing the mild mental retardation or more severe retardation. The not likely to be reversed, I think you're looking at whether or not medication would help. And we know that some of these real serious diagnoses of schizophrenia, bipolar, these personality disorders, sometimes the medication works, sometimes it doesn't. And on some of them, the medication has such serious side effects that the parents have trouble staying on it. And there's usually an up and down roller coaster ride on whether they're on the meds or not. Again, we talked about it has to have a documented condition. It has to be permanent or not likely to be reversed. And that permanent, you also see when the parent has a history, a long history of mental illness. And you usually see that in the evaluation. And lastly, it has to be so serious that they can't care for the child. So a lot of times I think you're looking at it so serious they can't take care of themselves. On the other end, you have the parents visiting and doing minimal things, and the mental condition may not be serious enough that you can do that. Again, guys, relative placements are a great place to put our kids, especially when you have these mental conditions that the parents have. It's a great place to place the kids with family and let the family be involved and maybe do a guardianship instead of termination of parental rights if you don't have a parent that where the condition is so severe they're unable to parent the child. Let's see. Let's talk about chemical dependency. Okay, And this was an actual case. In one case, mom had some sort of drug problem, they thought, and she'd been testing positive off and on for a year. Maybe one or two drugs, one sometimes, the other sometimes, but there was never any type of evaluation done. And when I asked them about, well, what types of prior treatment has mom had for this chemical dependency? Well, she hadn't had any. So this was just the onset of a drug problem. And yes, the child had been in care for a year, but you don't have the untreatable parental chemical dependency because you don't have multiple attempts at drug treatment. You don't have multiple attempts at inpatient. You don't have multiple attempts at outpatient, AA, NA. You don't have that history of all of that. You don't have, a lot of times on these severe drug cases, the untreatable type, you see a lot of criminal convictions based on either possession of drugs or distribution of drugs, depending upon how serious it is. So, and then you have removal of a child, and those are very severe consequences, and they continue to use despite that. But it's not untreatable if you don't have any history of it being treated inpatient or outpatient. You're looking at something where there's been repeat treatments, inpatient, aftercare plans, then they relapse, maybe they do outpatient, maybe they do multiple inpatient treatments. You're looking at all of that and need all that documentation to be able to say that it's untreatable. On the failure to rectify case, sometimes the question comes up, well, you know, the parent's going to be in prison for a couple years. You know, why are we working reasonable efforts with a parent that's in prison? Well, I do think you can make a failure to rectify on a parent that's in prison, and the case law does support that. And newsflash, you can do reasonable efforts with a parent that's in prison. If their conduct is good and they're not doing all this volitional action that gets them put in an administrative segregation, they can probably attend the FST meetings by phone. They can probably have input into what's going on in the child's life. And in most cases, you can work with a parent who's in prison like you can a parent on the outside, in terms of there's all kinds of prison programs. And again, all of that information is available on the DOC website or may be obtained from central office from the PDS over foster care programs. But you can work with that parent. You can come up with a written service agreement about the different types of things they need to do while they're in prison to better themselves, to change their circumstances, to learn how to parent. So you can do that. And you can also do a written service agreement that says, and when you get out of prison, you're going to have to do X, Y, and Z. And some of our parents get out in 6 months from the time the child comes into care, or a year, or 2 years from the time the child comes into care. So you can do the written service agreement. The parent can be on the phone if the arrangements are made to do that. And you can ask them to do those things. It's really important for the worker to have a relationship with that contact at the prison to be able to do that. Again, I'm going to bring up that notice to incarcerated parent. That's a great thing to use, that you tell the parent, look, you need to do these things. You need to maintain the relationship. You need to provide support to the child. You need to tell us who their relatives are for placement. You need to be involved in your child's life. And then again, on the back side it says, and oh, hey, if you don't do this, then you may be subject to having your rights terminated. So I think that works pretty good. I don't have a question on this one, but on the number 3 on the factors, the social service plans and extent of parental compliance, I think what it really comes down to is, what is the parent complying with and what not, and what are they not? The courts talk about some compliance is enough for you not to be able to TPR on this particular factor. But I think you're always okay if you look at the safety issues. What are the safety issues that brought the child into care? Has the parent addressed those safety issues? And if the answer to that is no, and you've provided every reasonable effort you can and put it in your written service agreements, what they needed to do to address those safety issues, then I think you will have that number 3, the social service plan and the extent of parental compliance when they have not complied. And I think that's how you answer that one. With that, we're going to end on failure to rectify. Let's take a look at parental unfitness as a TPR ground, and this is our last one on the day. So both elements are required. We're going to talk about the two elements, but I'm going to focus to begin with on the note at the bottom of the page. So what are the two elements? The parent is unfit to be a party to the parent-child relationship because of a pattern of abuse, and we'll talk about what that is, or a specific condition related to the parent-child relationship. And then the second one connects the dots to the harm to the child. So the pattern of abuse or the specific condition renders the parent unable for the reasonably foreseeable future to meet the child's ongoing needs. So again, you're looking at potential for harm to the child. Okay. Now, how does this work on the front end of our cases when a child first comes into care? How does that statutory exception apply? Well, under the statute, if there are prior involuntary TPRs, you can opt out of reasonable efforts and go straight to TPR and adoption. That's one of the exceptions in the statute. The important thing to note here is that prior involuntary TPR has to be within 3 years, note the 3 years, of this TPR trial date. So you've got a new child that's come into care, and the date that you do the TPR for parental unfitness has to be less than 3 years from the date of the prior TPR. So it's relatively short period of time. The first question that always comes up on this prior involuntary piece is, does it apply to consent TPRs? No, it only applies to involuntary TPRs. The next question that comes up is, how does it work? Well, it's a way to legally shift the burden of proof. And basically what the statute said is, if you have a prior involuntary within 3 years, that's a slam dunk that this parent would be harmful to the child in the future. And therefore, the burden of proof then shifts to that parent to prove that they've changed their life and changed everything, and that condition no longer exists and is no longer harmful to the child. So that's the important part of that part. So what are the specific types of abuse? And we went ahead and put those on the next slide if you're going to use this as a regular TPR grant. The specific types of abuse would be adult abuse. So the child is witnessing adult abuse and has subsequently been abused or neglected. There's been child abuse in front of that child, or they've been abused. There's been drug abuse before the child. And again, we have kids that sometimes can go into great detail on the paraphernalia that the parent uses when they do their drugs. How they crush it, how they shoot it up, what instruments or whatever they're using, or medication, whatever they're using, and how do they do it. So, that shows that obviously it's being done in front of the kids. Or some other specific abuse, and you have to name specifically what that other specific abuse would be. And remember, it's not just specific types of abuse, it's other specific conditions directly related to the parent-child relationship. So this has been, the specific conditions directly related to the parent-child relationship has been used occasionally when you have a parent who's incarcerated that is a lifelong person with multiple convictions, and they get out of prison for a short period of time, have a relationship with a woman, commit another crime, and go back to prison. So basically, for these type of people that spend their life committing crimes and spend almost most of their adult life in prison, sometimes that can be used. It's been used successfully a couple times. But I wouldn't say to put all your eggs in one basket and say just because the parent's incarcerated you can use this ground. No, we're looking at a lifelong criminal who spends most of their time in prison, and just when they're out, a child ends up being conceived and born, and the parent's in prison and will be there for most of their life or for a serious period of time. But you have to be able to specify the type of abuse, and you have to be able to specify the conditions that cause that parental unfitness if you're going to use this grant. So let's go back and talk a little bit. I think I have 2 more questions and we're finished with the training. So we talked about, if you're going to use that presumption of unfitness, that it's got to be 3 years or less old at the time you try this new case. So my recommendation is you're looking at 2.5 years is how old you want it, because it takes a while to get your TPRs referrals done, to get them filed, and to get them tried within a year or so, 6 months to a year of how old this one is. So you're looking at 2 years, 2.5 years, if you're going to go with that at the beginning of your case and move straight to TPR and adoption. Okay, here's a question. There's a prior involuntary TPR judgment from the court in my county on a parent whose new baby has just come into protective custody. Can we go straight to TPR? So the answer is maybe. It depends upon how old that judgment is. Remember, for that presumption of unfitness, it has to be less than 3 years old at the time you try the case. And it will also depend on what the TPR grounds were in that prior involuntary. So the presumption of unfitness only applies if the prior involuntary judgment is within 3 years prior to the TPR hearing on this new baby. So we understand that. And the presumption does not apply if the prior involuntary was for forcible rape or for parental unfitness. So you're looking at the prior involuntary has to be on abandoned child. It has to be on abandoned infant. It has to be failure to rectify. It has to be for abuse or neglect. Or it has to be, say, the felony sex offenses. Those are the ones that would qualify for that. Last question. I have a prior involuntary TPR on a dad from New Mexico. Can we go straight to TPR? My answer to that one is also going to be maybe. The courts have made it clear that you can base your presumption on a prior involuntary that was done out of state. Now that's clear. But again, it depends upon how old that judgment is. It's got to be less than 3 years old at the time you try the new case, TPR. And it depends upon what the TPR grounds were that were used in that particular judgment. And again, sometimes out-of-state judgments may be handwritten, may be very difficult to read. It may not be clear what the TPR grounds were that you want to base that on. And I've actually seen this on at least one occasion. So if you can't tell what the TPR ground is in the judgment, then you're probably not going to be able to use it as that presumption of unfitness because it's less than 3 years old. If you can't tell what ground it is, then the parent's not going to be able to get their full due process and have notice of what it is that they supposedly have done wrong. So the recommendation is you want to be able to read the judgment. It's got to match up with one of the Missouri TPR grounds. You want to get a copy of that judgment, and for trial you'll need a certified copy. And you want to get a copy of that state statutes for TPR so it's clear what they are on. And I think it will take all of that for you to be able to do this. So we've gone through 4 of the TPR grounds today, and I hope these frequently asked questions have helped you in your decision making.